Okay, so we have a time for Q&A, and we'll have a microphone, and the gentleman who first asks will be first. And if you hold the microphone horizontal, it'll work best.
Okay. Yes, this question is for the first speaker. And I have to take some exception with the characterization that you made of California gun laws. Unlike most laws that seem to be taking guns away from people, I'm not in law enforcement, but there's at least 4 people in this room, including myself, that are required as a condition of employment to go out to the gun range and qualify once a year with 3 different weapons. Every time I go out there, I see lots of AR-15s and AR-15 derivatives. So I don't think that you should make the carte blanche statement that you did, that you would never come to California because they don't like your gun. I think if you're willing to bring your AR-15 with a magazine restriction on it, somewhat less than 35 or 40 rounds, you'd be entirely welcome. And that's all I have to say. And I look forward to your response.
Oh, I'm very much pleased to. First of all, the original Roberti Ruiz law specifically mentioned the Colt AR-15 as banned, and if any gun that has a Colt AR-15 engraved on it is banned in California, no matter what the characteristics. You could take the pistol grip off, you could fill in the hole where the gas goes through to make it be semi-automatic, you could do anything, and just because it's called that, the name itself is banned. And then there's the characteristics. There are things you can do to take a gun that looks like one. You know, Colt brought out the Colt Sporter after that. And of course there's a lot of other generic guns that are similar to it. Colt Sporter was not an AR-15, and it was not banned originally. But then California adopted the generic definitions, including the pistol grip that protrudes conspicuously beneath the action. But it's still got to have a detachable magazine. There's a device that you can make the magazine non-detachable, because if you have to use a tool, including cartridge case, to push the button of the detachable magazine, then it's no longer detachable. Gene, on calguns.com, you've got some good analysis of this, don't you, about ways of getting around it. So there's guns in California that look like AR-15s, but there's something about them that makes them legal, that such they're not the original full configuration AR-15s. Some of them are Colts, and there are other brands as well. I'm using that AR-15 generically now. Mm-hmm.
Can you imagine if your right to print was only available in California if you printed on paper that was 15% recycled, or that the ink only had a certain lead content, or that you could only use a certain font? I mean, if it's a right, okay, then it's a right. Look, the point is this. The only kind of criminal work I do in my office is I do only weapons cases. I don't do drug cases. I don't do theft cases. I don't do anything else. I have the pleasure of representing some of the most upstanding, law-abiding citizens I've ever met. It's usually somebody who has no criminal record, who got caught in their car or going to or from the range with what a cop thought was an AR-15. It probably isn't an AR-15, but they have to spend thousands of dollars to hire some shyster like me to go to court, show the district attorney where he's wrong, and have the case dismissed. That is an injustice. That is a chilling of the right. And that's the problem with California's ungodly Rube Goldberg machine of laws that there are. Yeah, if there's going to be laws, they need to be simple. Thank you.
How about the gentleman right in the back?
Thank you. Could you speak more, sort of, just back up a little bit and speak about the importance of the Second Amendment as reflective of the notion of individual rights in general? It seems like for many people that are not gun people or live in suburban communities where there's rarely that much crime, the whole notion of the right to bear arms for self-defense or to be part of a militia seems a little bit abstract, but there's something important about this in terms of the nature of our society and who we are as a people that I think the Second Amendment might be speaking to. Could you comment about that?
Certainly, that's a great question. St. George Tucker, who wrote a book in 1803, the first commentaries on the Bill of Rights, said that the right to self-defense is the first law of nature, and that governments that try to take away firearms basically are approaching tyranny. Why is this the first? Self-defense is the first law of nature. You can't do anything else in life if you can't defend your life. And that's why, for example, during the Reconstruction period, the freedmen and also, in other words, the freed slaves and also carpetbaggers who came down after the war, Republicans, they were often threatened with violence at political meetings, for example. So you can't even exercise your rights to free speech and to assemble in some societies without being able to protect yourself. But even if we take it outside of the context of an oppressive social system like existed there, we have the right of individual self-defense against criminal conduct. And for those middle class or suburban places where there might not be much crime, you know what? Firearms are a tremendous recreational tool. There's nothing like shooting at clay pigeons, and there's nothing evil about it. There's nothing evil about the Olympics who shoot with handguns or the ordinary people who shoot with handguns at target ranges. It's a wonderful, wholesome activity for families to be engaged in. Hunting is a wonderful activity by the same token. There's many reasons to possess guns, and they include the most serious reasons like self-defense, defense against tyranny, but also reasons for recreation, sport, and hunting. So depends on who you're talking to as to what might be persuasive, but not every society is perfect and not every society remains perfect. And if you think about the conditions that are described in this book, Securing Civil Rights, the baseline for survival for many people in those days was the ability to merely possess a gun to defend their families.
I got it.
You want to make that? It's not my idea. It's Stevens from his book, and that is that there were actually some Reconstruction legislators when they were debating the 14th Amendment who made the argument that, well, we don't need the 14th Amendment because the 13th Amendment that abolishes slavery has an implied right to keep and bear arms in it because, taking guns away from people was a badge or incident of slavery, which is what the 13th Amendment abolished. So, the idea that being stripped of the right to keep and bear arms puts you in a class or a position of servitude is not a new idea.
She handed me the microphone.
Before you do, I have a question. Since we have people also hooked in by live stream, I have a question from one of them. The question is, considering these recent legal developments, what can we do legally and politically to fix this issue so that people are not arrested for transport and carry nationwide?
Well, everybody has a role to play. Everybody's important, whatever walk of life you're in. And the best advice I can give you is join the National Rifle Association, join other firearm organizations, join gun clubs, and be conscious of your rights. For example, how many of you know there's a federal law that you can go through if you start at a place where it's legal to possess a gun, go through a place where it's illegal to possess it, to a place where it's legal, that you're immune from prosecution under a state or local law. Because the questioner did make the point about traveling with guns or transporting guns nationwide. If you go from Virginia to Maine on a hunting trip and you go through the state of New York, for example, and you're going handgun hunting in Maine, in New York State, it's a crime to possess a handgun. and it's only an affirmative defense if you have a license, and it's only available to a New York resident. So the federal law protects you. You can travel by airline with firearms under that same law. So the best advice I can give you, though, is if you are in a legal situation, a lot of lawyers don't even know about that law or other laws that might be pertinent, and you've got to find competent legal counsel, those who know those issues.
There was just one. You want to ask about the considering FOPA in there.
Well, the law that I'm talking about is part of the Firearms Owners Protection Act of 1986, and it's 18 U.S.C. 926A, and that's the very law that was passed because of these states that have restrictions. Congress wanted to make sure that people could travel interstate in this country without fear of local laws that restricted that kind of travel. And so a lot of people were arrested when they had accidents on the New Jersey Turnpike. New Jersey has very strenuous laws. So the Firearms Owners Protection Act is the very law that I'm talking about that protects this right to transport firearms as long as they're inaccessible and unloaded, and depending on the type of vehicle, for example, if it's a car, it's in the trunk. Then as long as you meet those standards, then you can transport the firearm.
I'd like to add to that another anecdote that I've come across in the past couple of years, and that is be a proud gun owner. Okay, I can't tell you, I've been a member of the bar for about 15 years now, and I've been doing gun litigation ever since I was a new lawyer. And I'd get some strange looks from judges and fellow members of the bar, but pretty much a lot of silence, stone silence. Ever since Heller and McDonald have come out, and of course the cases were very well publicized and very controversial, it got the public talking about it. I now have some judges and some lawyers coming up to me and talking about guns and talking about the guns that they own and how they like to shoot. And so it's, gun is no longer porn, okay? It's okay. It's okay to talk about guns as something that's good. I mean, it's an instrument for exercising a constitutional right. So to add to what Stephen said, be a proud gun owner.
Okay, go ahead.
I'm wondering if you might comment on stare decisis. I'm not a lawyer, but Heller was 5-4, so I expected McDonald to be maybe 6-3 or something a little more decisive than 5-4. How confident can we be that the Second Amendment will stand in the future, if you have an opinion?
You can be confident as long as the 5-4 balance doesn't change. So thank goodness that Kagan is replacing Stevens. Two scenarios could happen. If it happened in the near future that balance was changed, you could have a reversal of one or both of those cases. Or if like free speech cases, if we build up a couple of decades of cases and it gets to the point where there's no turning back. But then if the balance changes, something else can happen, namely that what a wonderful right this is, but nothing ever seems to violate it. So yeah, it's an individual right, every one of you possess it, and it applies to the states, but gee, they can demonize a certain kind of, or they can say all rifles are potential sniper rifles and therefore ban all rifles. I mean, you could have a result like that where a right is recognized, but it's so whittled away. There used to be a phrase, the incredible shrinking Fourth Amendment. And it has to do with the fact that you read the amendment, you think warrants are required. But there's so many exceptions where warrants are no longer required because of judicial decisions that how much of it is left. And I think a lot of it's left, but a lot of it's gone as well. So anyways, those are the two things that can happen, that there could be a complete reversal, or if we've gone too far that that's not possible, there can be whittling away at the right.
How about, super on the side, let's right in the aisle first, and then we'll move over. Yeah.
A couple of days after McDonald was decided, the America's newspaper of record, the New York Times, read an editorial. Not surprisingly, the legal scholars on the Times decried the decision, and they had a few letters published which were going along with the Times editorial view. However, one of them was very interesting. And that letter discussed the fact, or made the statement, that the Second Amendment's reference to a well-regulated militia was not a reference to a government organization, but rather something that we'd call an NGO, something like the American militia. In other words, a group of private citizens who would organize themselves. Is there any basis historically or legally to support that kind of distinction as opposed to the use of the 14th Amendment and an individual right?
I think as originally understood, a militia could be a broad concept. You had the term well-regulated militia used often, not only in colonial times, but even in England. And you had two uses, basically. You had militias that were organizations that were under the auspices of states. Once they were newly independent states, they declared themselves independent. Each state had its own militia law, and you had to be enrolled. Every man had to be a member of it, and you had to provide your own arms. And the first Federal Militia Act of 1792 was the same way. But you also had, for example, George Mason and George Washington starting up the independent Fairfax County Militia Company in 1774. And I think they put up some of the money for it to help people out who didn't have enough money to get equipped. And those people voluntarily formed these militias, basically in opposition to the Crown's forces and the Crown's militias. So I think the term, as originally understood, was flexible enough that it would include any association of law-abiding people who come together for a common purpose of exercise in martial endeavors and marksmanship and things of that type.
Two things. First, on the carry permits in California, if you have a right to bear arms, how can the permit be left to the discretion of a local official without any objective standards? In other words, the sheriffs or the chiefs of police under the California statute are entitled to grant or deny the permit on their individual whim without any standards. And if it's a right, how can it be left to somebody's discretion? That's the first question. The second one is a sort of a question, but more a comment. Why is the legal profession so shy that it will not state flatly that Justice Sotomayor revealed herself as a perjurer? Why not just, it's clear, it's a blank statement. Why does the legal profession shy away from facing an obvious fact?
Well, that's a loaded question, since I may appear someday before the U.S. Supreme Court, and God forbid Justice Sotomayor sees this. However, if I were to defend her on a charge of perjury, I would simply point out that all she said in her testimony was that she agreed with Heller, which meant she agreed that the Second Amendment was an individual right. You didn't need to be a member of a militia. I don't know that she made any comment in her testimony with regard to incorporation. So that would, I hope that it.
She said she can't comment on that.
Yeah.
She said she would reverse the Heller case. She pointed an opinion that said that she would reverse Heller.
Okay. Well, I don't think she's guilty of perjury by the standard of perjury. The first question you had, refresh my memory. Carry, yes. The law in California right now is, there's this controversial practice that's taking place right now that the legislature is rushing headlong to try and cure, called unloaded open carry. It's not illegal to carry a weapon in California in public as long as it is not as long as it is exposed and it's unloaded. It's a dumb practice, okay? Because you're just going to draw attention to yourself, and you're going to have a lot of police officers, giving you a lot of attention you probably don't want to have. The permit is only required for concealed carry. The states of Alaska and Vermont do not regulate concealed carry. Perhaps in a perfect world that maybe Arizona's going the same way. Maybe in a perfect world that would be the ideal. But Heller and McDonald affirmed as well that regulations on the concealed carrying of weapons are probably going to be okay even with the Heller and McDonald 5. So we've got to live with that. Where there is room for litigation is that clearly, because we're still talking about a fundamental right, there have to be objective standards. It cannot be an arbitrary and capricious awarding of permits.
Okay, this gentleman right over here. Just wait for the mic.
You know, I'm very interested to see the interest there is in defending civil liberties because I think they're important. But I'm been struck by the relative silence of many of the members in the NRA community over the challenge to our civil liberties in other areas, with the challenge against habeas corpus, with the challenge with the expansion of the secrecy with which our government now operates. A series of articles in the Washington Post this week that show that we now have a national security state that views us all as enemies. The surveillance state has expanded greatly, and I think that those pose much greater threats to our individual liberties than whether we can hold own arms or not. I mean, they could take us out as individuals very easily, but with the threats against habeas corpus, the threats against our own privacy rights, our rights to our own liberty, I don't know why, particularly among this community, there isn't more interest in defending us against those sorts of incursions on our freedoms. And I think there should be much more attention paid to that, because that's where a real threat is. That's the sort of police state practices that we objected to in the USSR practiced them. Why we don't object to them as much here baffles me. Do you have any comment on that?
Yeah, before I turn it over to one thing I might mention is that we have the Institute is completing a book currently on habeas corpus for the very reasons you're giving. And also I would recommend going to our blog called The Beacon, and one of the most recent posts by our senior fellow Robert Higgs is applauding the priest articles that you're referring to at the Washington Post. It's actually part of a series they're doing.
Well, he's a hero, but he's very much out of the mainstream of even the Independent Institute, and certainly does not reflect the view
if you look at
of
what
most people on the right.
I think you'll find what the Independent Institute does is cutting edge on the whole issue of civil liberties. So I'd recommend that work, but I'll turn it
But
over
I'd like
Steve.
to direct this to, because I sense our speakers here perhaps should have an interest in the broader question,
Yeah.
if we were going to discuss the broader question of our civil liberties. How does the attitude of, say, the NRA, for example, speak to these issues? Because I think that they're far more important in terms of the threats that we face from our government than the right to own an AK-47, for example.
I mean, I think that one of the things, before I turn to Steve again, is that the rise of national security statism, certainly in the post 9/11 situation with Patriot Act and many other measures, which includes renditioning and all the rest of it, is a very serious problem. And one of the great advantages, in my opinion, of what Steve and others have been doing is to insist that the Bill of Rights, the incorporation, is something that's key. And fortunately, these decisions have been made, and our view is that hopefully this will open up a lot of minds and legal precedent to these consistent interpretations. Steve?
As we speak, the NRA is involved in strong opposition to bills in Congress that would take away your right to own a gun if you're on a terrorist watch list or no-fly list or any of those secretive lists that who knows who compiles, lists that you can't get out of, lists that Teddy Kennedy was on, and Ginsburg was stopped at an airport once for being on one. Well, there's some people who aren't qualified to own guns, maybe, but Ginsburg would be okay. I mean, she's not a violent person, but look, there are special interest groups on various topics, and those groups cannot be effective unless they bring everybody who has an agreement with that particular agenda. They're in a no group can be everything to everybody. I totally agree, except the Independent Institute. I think most likely everybody in this room agrees with what you're saying, and And I have a strong civil libertarian background, and I can tell you that when the Waco and Ruby Ridge incidents happened, and we had this this police state kind of mentality, which we have certainly an element of now as well, but we had a particularly strong one then, where federal agents could go around and shoot boys in the back when they ran away, and start conflicts that result in scores of people being killed. The NRA, the ACLU, and the American Criminal Lawyers Association formed an alliance to try to work together and fight that kind of police state mentality. And so you see, when you have a single issue organization, and when an issue like that confronts it, for example, the issue of being on the terrorist list, where the government can deny you the right to even buy a gun, then it's an issue that affects that group, and they can take action. But it's like there's another NRA, the National Restaurant Association. You wouldn't expect them to be involved in issues having to do with boating or something, or in the non-fishing context. All I'm trying to say is that you've got to have a division of labor. I work primarily on the issue of the right to keep and bear arms, but I'm certainly, as a citizen, interested in not seeing our country become totalitarian for the same reasons you're talking about.
Right here.
To both of you, it seems to me that we still have some vestiges of the black codes, specifically disparate enforcement in African American and communities of color, and certainly disparate sentencing, and as applies to weapon charges and to so-called gang enhancements. And I'm wondering, particularly both of you talked about an apartheid extension in the South, and you, of course, have written about the Freeman Acts. What can you say in reference to NRA litigation to protect and not chill the right to bear arms in those communities? And what are either of you doing in that regard, or who else is litigating in that regard?
Well, one thing I should mention is that there's a variety of groups involved in gun rights litigation. So, anyway, Steve.
I'll just make a brief comment, and I think Don would probably comment also. Washington, D.C.'s first gun law was African Americans couldn't own guns, and I've represented on multiple occasions African Americans in Washington, D.C., trying to restore their right to keep and bear arms. And there are, I'll mention one name, Absalom Jordan. He's been a community activist in Washington, D.C., on behalf of the African American community, particularly in regard to the right to keep and bear arms since the 70s. And Sandra Seegers is another person who's done the same in Washington, D.C. But you have the elected leadership frequently are under the control of a political party or political factions that don't trust the people with arms. And so you have these kinds of restrictive laws passed that have the most impact in communities that are poor or minority communities. And you have that acknowledged in the McDonald opinion, the fact that here you have Mayor Daley and, they get these laws passed, and where are most people getting killed, and who are most of the people getting killed? It's the people in the very communities where these laws affect them the most, because the law-abiding people in those communities cannot possess firearms. So I think all of any organization that's promoting the right to keep and bear arms in the litigation context is going to be on the lookout for that. In the public housing context, I represent an individual in Washington, D.C., living in public housing, and they said he couldn't have a gun. And it's the poor people, obviously, by definition, who are in public housing. So you're telling them basically that you live in public housing, you can't have a gun. You don't have all of your civil rights. I think we're all against that.
One thing I also might mention is that the natural tendency for government mandates, regulations, and so forth is that those who are the least politically influential end up paying the price, and they're the most discriminated against because they're the most marginalized, and it's least costly for those who are in political authority to be accountable for it. Right here. Oh, I'm sorry. Did you comment? Yeah, sorry.
Yeah, the racist roots of gun control is pretty well documented, in Stephen's book. I mean, even in California, as California became entered into the union and started putting together a legislature and drafting its own, public safety statutes, it was very common to read city and county ordinances and even state laws where the discussions were very racist. I mean, the particular race that was attacked out here in California were the Chinese. The bigger disparity that I find, though, in my practice is between urban and rural counties. I live in Santa Clara County and practice there, so I'm kind of on the edge of the Bay Area, the densely populated urban area, and then the more rural areas out towards the Central Valley. And, you get a guy who calls your office and says, I was coming out of the field hunting and I forgot to take a bullet out of my rifle. I got pulled over and I got charged with having a loaded gun in public, Penal Code Section 12031. So you go to court, you tell the judge what happened. Judge says, okay, give him his gun back, $400 fine. See ya. That same charge in downtown Oakland will get somebody a mandatory minimum sentence of 30 days in jail. Okay? So really what we're finding is an extraordinary bias against guns, almost bordering on the mystical in the densely populated urban areas. So it really breaks down more along the lines of gun culture versus the nanny state more than I see. I'm not seeing too much in the area of racial classification at this point.
Incidentally, to plug yet another book, this is a book that we published at the University Press of Kentucky last year. It's called Race and Liberty in America. It's a collection of about 100 documents over the history of the United States by many different figures, some known, widely known, some unknown, about the history essentially of government and liberty and how that's affected racial groups of most types, including Chinese through the Chinese Exclusion Acts and many others. Okay. Here's another question from the streaming. How do you see the Second Amendment landscape changing in the next 3 to 5 years in California?
Go ahead, and I'll have a comment too.
Well, the Second Amendment, because it's a federal right, is going to be basically imposed from the top down on state and local or city and county governments and on certain state statutes. So, the Second Amendment's not going to change from its interpretation by the U.S. Supreme Court in Heller and McDonald in any decision that comes out. The primary issue left for litigation right now of a constitutional nature is going to be, standard of review, whether or not gun rights get strict scrutiny or some sort of watered-down version of intermediate scrutiny. So that's going to be where the hot ticket is for the foreseeable future.
And I'll just add to that on a more practical basis, the assault weapon ban, the arbitrary denial of carry permits. Those are two very primary areas. The requirement that you give fingerprints, I think it is for pistol ammunition. I mean, a constitutional right, you're having to give fingerprints for it. So one thing I would say, though, is we don't want to encourage people who aren't prepared to rush out to the courthouse door. Since this is being taped and so forth, we have a broader audience than here. And I want to say that don't represent yourself and bring a case, because then you're going to create bad precedents. And if a case is going to be done by an attorney, the attorney should be somebody qualified in this field. You wouldn't go to an attorney who does auto accident cases to do a complex medical malpractice case. We've got bad precedents set because attorneys who were good at heart but they were only retained because they were a member of a local gun club but didn't know anything about firearms law, did the lawsuit. So there's going to be a lot of cases. They're going to have to be carefully prepared and litigated to be successful.
How about the gentleman right there?
Is there any compelling evidence, empirical evidence, that draconian arms laws actually increase crime compared to those jurisdictions in which the arms laws are much more liberal in a classical sense?
Maybe we both have a comment. Well, I guess there's a lot of evidence that prohibition creates organized crime. There's a big debate in the academic community. John Lott's book is the most famous one, More Guns, Less Crime. Justice Breyer, if you read his opinions in these two cases we've talked about, he always takes the side of those who are adverse to that view. But I think we all know that in the places where the guns are banned the most, they have the most crime. And the question, though, is what is the causation? And you know what I've always thought about that? I don't care what your statistics are, it's a constitutional right. So don't come to me with a lot of statistics saying that justifies banning a constitutional right. There'd be a lot more crime solved if the police could use the third degree and if people didn't have lawyers, if you didn't have to get search warrants. The whole Big Brother society, I mean, I'm sure there's not much crime other than by Big Brother. So it's a debate that I choose not to be in, by the way, on crime data and all that, because it's a constitutional right. It doesn't matter what the data shows. And what is it? What do they say? Statistics don't lie, but liars use statistics. So.
Yeah, we made a conscious decision in the Nordyke case not to use statistics. I mean, we had a wonderful laboratory of experience because gun shows have not taken place in Alameda since 1999. But we've had 11 years almost of crime statistics in Alameda County that do not purport to show any correlation at all between the lack of gun shows at the fairgrounds and both the rise and fall of murder rates in Oakland, or actually in all of Alameda County. So Stephen's point is well taken. Once you start talking about statistical basis or a statistical foundation for a constitutional right, you're going to find public policy analysts who are going to be able to shoehorn any gun regulation into a set of crime statistics. I think Justice Scalia said it best in Heller. It's a constitutional right. Certain policy considerations are off the table.
The gentleman right in front, and while we're waiting for that, I have another streaming question. What about forcing someone to apply for the ability to carry across the country without having to go into an office? And there's a second question, which is slightly not related. Considering parade permits can be done via fax and postal service, why can't carry licenses?
Well, residents of, I think, every state can apply for a carry license from the state of Florida or Utah, or there's certain states where you don't have to be a resident. And will there ever be a license where you can carry all over this wonderful land? I don't anticipate there will be, but it was said best by the court in the Dred Scott case that if African Americans were citizens, they could keep and carry arms wherever they went. And that should be the right of an American citizen. It's not. The Supreme Court, as Don mentioned, did countenance laws on concealed carry. That's a 19th century concept. Today, the concept by state legislatures, by and large, is to encourage, instead of open carry, concealed carry with permits. And I don't think, despite what the Second Amendment literally says, there's a right to bear arms, I doubt you're going to find courts saying that there's a right to bear arms if the legislature so requires without a license or permit.
What about
Well, like I said, in some states you can get a concealed weapon permit by mail. You send in the information they want and photograph, fingerprints if they require it. But places, I mean, some places to get, like to register a gun in D.C., you've got to make at least 2 personal appearances. That's something we're objecting to in the litigation there. But I think what's being asked are questions that come from an ideal world. And we don't live in an ideal world, and we have to start where things are worse and try to get rid of the worst things first and then move on.
Okay.
I feel kind of funny arguing against somebody who's argued with the Supreme Court, but something that was said earlier about a Colt AR-15. If an individual in California owned that Colt AR-15 at the time Liberty Rules was passed, it was grandfathered in. It had to be registered and has to be registered, I believe, on a yearly basis.
It had to be registered, but not on a year. Yeah, part of what you said is a true statement. If you owned an AR-15 on the date that the legislature declared it contraband, it was declared contraband unless registered. The registration, I believe, is for the lifetime of the gun owner. What happens to the gun after you die, what your estate does with it, the legislature hasn't answered that question, okay? But the Liberty Ruse was a registration scheme. Part of the problem is, implication of what you're saying is there could be 2 guys standing next to each other at the range. One guy has an AR-15 that was grandfathered in. He can, remove his detachable magazine. He can have high-capacity magazine. He can have, folding stocks and all the evil features. The guy next to him is stuck with a Ruger Mini 14 or something. And they're shooting the same ammunition, by the way. All right. So, yeah.
How restrictive do you think cities like San Francisco will be able to be on concealed carry permits and still pass muster? Right now, as I understand it, it's pretty much judges are about the only people who get them.
Well, yeah, but in California you have very good state preemption law, and there's been 2 major decisions on San Francisco. One decided recently, and one going back to I think the 80s. But in any case, your state preemption law takes care of San Francisco in most cases, and now the fact that the Second Amendment applies in San Francisco, that buttresses that and makes it stronger. So you're always going to see them trying to do funny things like those kinds of cities do. But as far as bans go, they're off the table.
It's a sanctuary city.
Okay, 2 last questions right here.
Okay, even before Heller and before McDonald, the California Constitution, I believe it's Article 1, Section 1, the first paragraph after the preamble says that all citizens are entitled to life, liberty, and I think happiness, words to that effect. Now, I don't expect common sense in Sacramento, but it seems to me that if you are entitled to life and liberty, you have the concurrent right to protect it. And now we add Heller and McDonald. It seems to me that that becomes strengthened, and is that an avenue to accelerate a more liberal policy in the state? I don't think we're going to see shall issue in California. But and as a strategy, would it make more sense for us individually in various counties and cities to approach our sheriffs and our police chiefs with a unified strategy, if you will, and get them to be more liberal in issuing CCWs, or does this have to be done at the legislative level?
There would be some argument if California had a right to keep and bear arms in its state constitution, for the state to make that would go something like this. Well, we have a right to keep and bear arms in our state, and we interpret it this way. And therefore, the federal government has to somewhat respect that under a 10th Amendment reservation of rights or something like that. But California's never had a right to keep and bear arms in its state constitution. And in 2000, the California Supreme Court specifically said that there's no right to keep and bear arms in this state, which means that in California, it is a clear and open field. California is going to be stuck with whatever the federal right is. And therefore, we don't really even, we can, you commented on a movie earlier from Casablanca. I'll do Sierra Madre. We don't need no stinking right in the California Constitution anymore. We have the Second Amendment, and it applies to state and local governments.
Any more questions? Okay, great. Well, thank you so much. I want to especially thank Steve Halbrook and Don Kilmer for their really unbelievable work. And Steve in particular for his scholarship, which has really made this movement possible, this legal movement and cultural change. And I want to thank all of you for joining with us. Steve will be available to autograph copies of his books, and we hope that you can get copies, and we hope to see you again next time. Thank you.